petition and appeal in the matter of Barrow and Laing.
Lady, may it please
Mr.
the court.
Weir.
I appear for the respondent. Mr. Weir and Mr. Burton appear for the appellant. There's a short application to be dealt with before the main appeal.
Right.
My lady, does the court have the unagreed bundle?
Yes.
There should be a short unagreed bundle. There's an application to adduce before the court some unagreed documents. The bundle is paginated, my lady. The application notice is at page 2, begins at page 2, and the witness statement in support of Mr. Hibbert, my instructing solicitor in the court, starts at page 6.
Yep.
Lady, has the court had a chance to have a look at that bundle briefly?
I'm reminding myself of it.
Can I just take the court through it very briefly?
Yes, please do.
There's two documents in this short bundle.
Yes.
The first one, my lady, is the joint statement of the accident reconstruction experts, Mr. Sorton and Mr. Johnson, and that begins at page 11
Yeah.
and runs through to page 23. That's a document dated the 20th of June 2019.
Yes.
And as I set out in my skeleton, there was a couple of things from that document that I wish to refer the court to. And I shall, if I call the trial judge the judge in my submissions throughout the day, apologies,
yes, of course.
my lady, but I hope that's acceptable to call him
Yes, of course.
that. The judge referred to part of the joint statement in his judgment, but there were a couple of elements of it that I wish to draw the court's attention to. First of all, on page 14 of the bundle, the judge in his judgment had referred to paragraph 17, the contents of that there was a sliding contact between the claimant and the offside of the vehicle, but also I wanted to refer the court to paragraph 16 as well. There's also, my lady, perhaps more importantly, the final element of this joint statement, which I wish to draw the court's attention to as part of my submissions. My lady, in the judgment, the judge refers at paragraph to some of the evidence at paragraph 62 of the joint statement, which is at page 21.
Yeah.
I also wish to refer the court to, more importantly, what's set out at paragraph 64, which is on page 22, which I will read, my lady, in Mr. Sorton's opinion. And Mr. Sorton was the expert I stressed for the claimant and the author of this joint statement. Given the agreement that the contact evidence on the vehicle is inconsistent with Felix Barrow's standing at the moment of impact, the issue to be resolved is whether the claimant was in the process of falling to the road surface in accordance with some witness evidence, or in the process of getting up following a fall in accordance with Master Stannard's description. The point being, my lady, that from this joint statement, unusually in this case, the accident and emergency experts, Hulse and Fletcher, had produced their joint statement before the reconstruction experts produced theirs. After this joint statement, and considering that paragraph, there was then further expert evidence from both the accident emergency experts and the reconstruction experts dealing with this issue. And that occupied quite a lot of time at trial, the accident reconstruction evidence, which I will take you to in course of my submissions. But it's important for the genesis of that to be understood by the court, my lady, and that's the genesis of it is 62 to 64 of this joint statement in June 2019. So that's why I want to refer to that. Mr. Hibbert explains in his witness statement that it was intended that the claimant's opening would be part of the bundle, and in error, his firm agreed the bundle for this appeal to not include the claimant's opening. It's only brief, my lady, and if I can indicate to the court certain elements of it that I wish to refer to. Page 26, my lady. Miss Rodway was counsel for the claimant at the time. On internal page 12 of Live Note. In the middle paragraph there, Miss Rodway had informed the court in April. if it's found by your lordship that Felix had run directly across the road and directly into the path of the car, then our claim will fail. We understand that given the timings would provide too little opportunity for Mrs. Merrett to react and avoid the collision. Second element that I was going to refer to in my submissions is on the next page, 27. And that is, there's an exchange, my lady, which begins on line 18 of page 13, running down to the bottom of page 14, which I won't read out to the court, which was, in effect, the claimant's position that the position described by Nick Stannard at the time of the accident was extraordinarily coincidental to Dr Hulse's diagram. Now, my lady, that is at page 58 of the supplemental bundle, and also in the judgment. There was an extraordinary coincidence hypothesis put forward, which of course, as a result of the evidence of Dr Hulse, fell away. And then on the top of page, internal page 15 on page 27, there was reference by Miss Rodway to the importance of the evidence of Mr. Sorton, the reconstruction expert for the claimant. And the importance of that, my lady, in a nutshell, which the judge did deal with, was Mr. Sorton's view prior to cross-examination that if the claimant, if Felix, and forgive me if I use the first name terms for the claimant and his main witness, Nick Stannard, and I know there's family in court, I mean no disrespect to them by using those names. Part of the evidence of Mr. Sorton, an important part, was that if Felix had been running across the road and had fallen into collision with the car, his momentum would have carried him onwards, as it were, across the front of the vehicle. But the evidence showed that Felix, after the collision, was displaced to the right of the vehicle into the oncoming lane. So that was a large issue at trial, which the Elisabeth doesn't have all of the live note, and your Elisabeth doesn't have to consider all of the reconstruction evidence, but it was a very significant element of the trial. And there was just reference to, by Miss Rodway, to the importance of that evidence to her case there, and also in closing, which is in the bundle. The final part of the opening I wanted to refer the court to is on internal page 38 of live note, on page 33. Line 14, my lady, Judge Hermer, and I should say that the judge had also been the judge of the pre-trial review 2 weeks beforehand when the bundles had been provided, I think either before then or shortly after that. Neither of you are suggesting that this case can be unlocked by reference to the experts alone. I mean, I understand to say they're important. They're important for throwing light on the central, potentially the only factual dispute between you, but neither of you are saying that one can safely resolve the case by reference to the expert evidence alone. Now, the record there, it's only my response that's recorded. Certainly, it's my understanding at the time that there was no demurral from that, and the next point after the judge says no is obviously Mr. Burton, who's junior counsel for the claimant, addressing the court without demurral from that. So, my lady, the unagreed bundle contains some very brief documents which probably won't need to be referred to again in the course of my submissions, or if they do, they'll be very brief. But I would respectfully ask the court to permit those to go in. I should have said that Mr. Weir's position is one of neutrality, which means this is not an opposed application, one that they don't consent to.
Right. And just help me if you would, Mr. Sullivan, this application was served very promptly, it seems, at 3rd of May 2022. So,
yes, it's within the 42-day time period.
Yes, and it would have become apparent, having seen the skeletons and calibrating the bundles as to what was missing.
Well, Lady, yes, and certainly there was just an error on the part of my instructing solicitors in respect of the opening of the claimant.
Yes.
And I refer in my skeleton to the joint statement of we call them A&R, the reconstruction experts. Because there was one other element in the accident reconstruction joint statement at page 15, which may well be of some assistance to the court, and that is the agreement between the experts about running speeds and walking speeds of an 11-year-old. But, Lady, I had referred to it in my skeleton, and as I say, in light of, although initially I think there had been a proposal for further documents to go into this unagreed bundle, by the time it was shrunk to just these two documents, by that stage then the claimant has a position of neutrality.
All right.
So, in my respectful submission, it won't prejudice this appeal. It doesn't interfere with the timings of it. It doesn't cause any issues.
It doesn't take Mr. Weir and Mr. Burton too much by surprise.
No.
All right. Mr. Weir, anything you'd like to say?
My lady, only that, as I've already given my learned friend notice, I consider that to be 12 minutes out of his time. He's made basically opening submissions to the court.
Well, as you understand, we've heard them do Benny essay. So.
Well, my lady, I'm wholly untroubled. It's a matter entirely for the court. It's just more evidence. This isn't taking the matter any further forward, but leave it there, my lady.
All right. Elisabeth. Yes, they'll go in.
Very much obliged, my lady.
Mr. Weir. I should say that we've had the opportunity and taken the opportunity to read the skeleton arguments, and obviously by reason of those skeleton arguments we've dipped into the core bundle and the supplementary bundle. But
I'm very grateful, my lady. My ladies, my lord, I'm opening this appeal against the following backdrop. First, as you can see, the order of Lord Justice Stuart Smith, which is actually at page 92 of the core bundle, grants permission whilst describing the appeal as just arguable despite the formidable difficulties facing claimants in seeking to overturn the central finding of fact made by the judge in what was evidently a carefully considered judgment. It's page 92, my lady.
Yep.
Secondly, the long-held view that judges at first instance have a significant advantage over judges on appeal in having seen and heard the witnesses give evidence and be subjected to cross-examination. And thirdly, the now famous observations of Lord Justice Lewison in the Phage case at paragraph 114, the reference for which is authorities page 172. I won't take the court to it, it's extremely well known, in which, amongst other things, he observes the trial is not a dress rehearsal, it's the first and last night of the show, and his reference to the hazard of island hopping in a sea of evidence. All of that, my lady, is of course well understood. And in the face of that, it is the case in our respectful submission that the judge below has erred, and significantly so. First, in his understanding of what we call the hard evidence in this case. Secondly, in failing to test the key witness evidence, in particular that of Nicholas and Mr. Gent, against that hard evidence. And thirdly, across the board, when seeking to identify the core issues in the case, when setting the standard of care of the driver, when applying plausibility theories to the evidence, and respectfully in his partial approach to the evidence of witnesses. And my lady, the judge's failure to appreciate the hard evidence and to assess the consistency of the witness evidence of fact against that hard evidence provides of itself a proper ground of appeal. In other words, a basis upon which this court, if it accepts our submission in that respect, is obliged to set aside the judgment below. And my lady, in terms of how and why, that can be described as a failure to take into account relevant evidence. That's one, if I can put it this way, label that can be attached to it. And that's a label that we know, amongst other places, from Lord Reed in the case of Henderson and Foxworth, paragraph 67, which is at page 131, and I might just turn this up, of the authorities bundle. We know that that forms a proper basis requiring interference by the appellate court. So, my lady, that's page 131. And there you're at the judgment of Lord Reed at paragraph 67, and it's been sidebarred. Your ladyship will see it follows that in the absence of some other identifiable error, such as, without attempting an exhaustive list, a material error of law, the making of a critical finding of fact which has no basis in the evidence, or a demonstrable misunderstanding of relevant evidence, or a demonstrable failure to consider relevant evidence, an appellate court will interfere with the findings of fact, apart from those cases, only if it's satisfied. And that's the plainly wrong test, which is analysed earlier, which he then explains is cannot reasonably be explained or justified. It can also be understood as an insufficient process of reasoning, which renders the factual findings unsafe. And if I call them labels, I don't mean disrespect to the labels, but I mean that however one describes it, that is a substantive, or what we sometimes describe as hard-edged basis of appeal. It's not just a plainly wrong in the round basis. It is the judge fundamentally erred in the process of reasoning that he took to reach his primary factual conclusion.
And that's what you're going to seek to demonstrate.
That's what I'm going to seek to demonstrate. The only submission I'm making at this stage is if that is established to this court's satisfaction, then this court respectfully is obliged to set aside the judgment. If this court then sets aside the judgment, it's in a position to do one of two things. The first is to assess, this court to assess, that the claim is made out for the claimant. Second thing is to order a retrial. And my lady, I would understand how unappetising a prospect ordinarily it is to order a retrial from the Court of Appeal, and how often it is the case, for instance, in appeals involving divisions on contributory negligence, that the court will grasp the nettle and resolve the issue in a more timely and proportionate fashion. But if it is necessary to order a retrial, then we would ask that one be ordered. It would certainly meet the overriding objective in this case for two reasons. First of all, this is a case in which the claimant is either not going to face contributory negligence, that's the concession/agreement between the parties, if the evidence of Nicholas is accepted in toto, or arguably face a small degree of contributory negligence if in fact the claimant ran out into the road before falling backwards and rising when struck by the car, and that's addressed right at the end of our appeal skeleton argument. And secondly, the claimant, who's now only 17 years of age, sustained a severe traumatic brain injury with physical as well as neuropsychological sequelae, such that at a case management conference the value of the claim has been put at £10 million plus. In other words, it's a very great deal of money, making all the difference to the claimant and to his family. My lady, if that is the course which would be open to the court, and the court considered it was not well placed to replace the finding of the judge below, then that's the order which we would seek. My lady, in terms of the structure of my submissions today, can I address 7 issues, starting with what the hard evidence established? Secondly, what actually was the core issue at trial? Thirdly, how the judge chose to approach determining liability in this case. Fourthly, the proper approach to determination of the factual conflict between the key witnesses. Fifthly, how the judge failed to understand the significance of the hard evidence on body position. Sixthly, how the judge failed to apply the hard evidence when analysing the witness evidence, which I will take in turn, witness evidence of Nicholas, then Mr. Gent, and then Mrs. Merrett, the respondent. And finally, how the judge fell into further error when supporting his finding as to how the accident occurred with his plausibility theory. Lady, can I start with what the hard evidence actually established? This evidence came in two parts, which combined to produce what we've called hard evidence, but could also be labelled incontrovertible facts. And the two parts are, first, the evidence as to damage to the car, and secondly, the evidence of Dr. Hulse, the consultant in emergency medicine. Can I take those in turn, please? Starting with the evidence as to damage to the car. Can the court kindly go to the judgment at paragraph 20, which is at core bundle page 67. We're down the bottom of page 20, page 67, my lady, paragraph 20, so your ladyship see. So there's set out in writing the areas of damage to the car. We set out in our skeleton argument that in fact there's also damage to the front offside headlamp, which wasn't recorded by the judge but is common ground was damaged. But more helpfully, your ladyship can turn over the page and look at photographs which don't easily disclose where that damage is. But if you then kindly turn over the page again, you get to figure 3. And figure 3 is very helpful because that gives a bit of clarity as to where the damage on the car was. So if your ladyship has page 69, figure 3 at the top, it's incredibly small writing, but actually in the side profile of the car, the height up to the top of the tyre is 0.6 metres, 60 centimetres. You may wish to essentially take that from me, my lady.
I will.
Right. That's 60 centimetres. And you can see that's pretty much level with the part of the front headlamp which we understand to have been damaged. And so what we see from this is not just the damage, but the only damage to the vehicle is front offside and low. Very low to the car. And I now turn to the evidence of Dr. Hulse. And this is a case the court would have noted from the judgment at paragraph 78, which is at core bundle page 79, where the defendant elected not to call their expert in emergency medicine, so ladyship see para 78 at the bottom of page 79.
Yes.
So that the only evidence in emergency medicine before the court is that of Dr. Hulse, although the judge chooses to refer to the evidence of Dr. Fletcher earlier in the section at paragraph 76. But actually, the only evidence before the court is the evidence of Dr. Hulse. And my lady, as to the contents of Dr. Hulse's evidence, we've set this out if you kindly go to our skeleton argument at paragraph 16, which is page 20 of the core bundle. And the reason I'm taking you to that is there are multiple references. And this avoids the need for me to labour through all of the references, I hope. And I do not understand any of what we've set out there to be in issue. I will seek now to go through this evidence. So the evidence of Dr Hulse is that the appellant was struck on the left side, his left side, by the car. And your ladyship will recall this is a case in which essentially the car is driving from south to north and the claimant is intending to go from east to west. And the strike caused fractures, and it's the strike, not subsequent damage, for instance, contact with the road. The strike with the car caused fractures to his head, his left elbow, his left femur, and his left tibia fibula.
So in your skeleton argument at 16A,
Yes, my lady.
you say left femur, left elbow, left jaw,
Yes, my lady.
and left ankle fractures.
I've just described head.
So when you say head, you're referring to the jaw.
I'm not, my lady. There's a passage in cross-examination of Dr Hulse in which he explains that you can be hit in one part and that the energy refers itself to a part that's weaker and can cause a fracture where it's weaker. So,
Right, so that we should amend that part of your skeleton then? Because by omitting...
no, direct to the left side, sufficient to cause the fractures to his left jaw. It's accurate, my lady. It's entirely accurate.
Yeah, so, but you referred to head, and if that's going to be significant in your submissions...
My lady, I'm very, very happy to take the court. I will try to do this in short order. If the court can kindly turn up the supplemental bundle.
I'm not disagreeing with you, Mr. Weir. I'm just saying that maybe better for my note, at least,
Yes, my lady.
that I include it in your skeleton argument so that I'm not
Yes, I'm very grateful.
mistaken when you go on to make submissions about the strike and the hard evidence.
My lady, yes.
Yeah.
For the avoidance of any doubt, I don't think anything turns on where precisely in the head.
All right.
But nevertheless, my lady, in order to establish this, can I invite the court to page 47 of the supplemental bundle, please?
Yes. Thank you.
And I'm going to go through it. It's something of a trot,
Yes, of course.
but I will go through it. I'll take you through his evidence. I think
Well, it
this-
could be that the reference is sufficient, but take
Well, my
your
lady,
own course.
I'll do it if I may now.
Yes,
Now
of
the issue's
course.
been raised.
Yeah.
So, your ladyship will see, when we're in, for the avoidance of any doubt, see page 30, the report of Dr Hulse, his first report of March 17.
Yes.
And if you kindly go to 4.02,
Yes.
likely position of Felix when hit. 1.
Yes.
I consider it likely Felix was either on his hands and knees or in a crouched position close to the road when he was hit by the car on his left side.
Yeah.
If you then kindly go over the page, 4.03,
Yeah.
probable mechanism of causation of injuries. The injury to Felix's head was caused by a severe blow.
Yeah.
As there were no wounds, this was caused by a smooth, flat surface, probably the lower front of the car. I consider it's unlikely his head injury was caused by contact with the road. So that's the head.
Yeah.
And then at little 3, the fracture of the femur is mid-shaft and transverse and was probably caused by a severe direct blow to the lateral thigh. Over the page, if I'm not going too fast.
No.
Little 5. I missed that, the knee. The knee was also injured. It's not a fracture, but the knee was also injured. But little 4. But little 5, the fracture of the left elbow is also probably caused by direct contact with the front of the car. And then the additional submission I was just about to make, which is also included in our paragraph 16E, is little 6. The front offside wheel of the car, and it says ran over the Felix's feet, and my learned friend properly cross-examined on this, and Dr Hulse recognised he meant to refer only to the left foot, and it was a mistake to refer to both feet. And he does, he says, later, the wheel going over the left foot would be consistent with the wounds to the top of the foot. And so, having made the assessment that all of those physical injuries, fractures, and as it happens also a ligamentous damage to the knee, were caused by a direct strike by the car, and given the location of the damage to the car, it should come as no surprise to the court. I'm sorry if your ladyship's just put away the supplemental bundle. I was
No, it's easily to...
I was just about to
easily to
continue
hand.
the trawl.
Yeah, I'm
because
just
I can
going
do
to
it.
make a note of our names.
Sorry,
to
Renee,
me.
of course.
So you were just saying something when you interrupted yourself to tell me to keep the supplementary bundle.
Some skill, my lady.
Yeah, takes some doing, but there we go. So you're saying the direct blow to cause the injuries.
My lady, yes. A direct blow to cause the injuries, given the location of the damage to the car, before one even comes to the evidence of Dr Hulse, would, by ordinary application of good sense, necessarily involve the claimant in being in a low-down, crouched position. Because how else are you going to get his head, his elbow, left femur, left knee, left tibia, fibula, damaged in a small area of damage to the low front offside of the car? To which one must also add his left foot was run over by the car, front offside wheel of the car. And this is not in issue. So that when one then goes back, if my lady you kindly will, to supplemental bundle, page 56, you'll see his Dr Hulse's Appendix 3 headed diagram showing the likely position of Felix Barrow relative to the front of the car. And that's why he has set out or placed the claimant in what he describes as a kneeling or low-down crouched position. In other words, it's fairly obvious how and why. And that's the diagram which your ladyship will recall later appears in the judgment.
Yes.
And if the court then kindly goes on, because I think it's safer just to take you through his evidence, his Dr Hulse's evidence in writing in total. If you again kindly go to page 82, you're in the first joint statement.
Yes.
And if you then go over to page 84,
Yep.
you've a description at the top. And although Dr Fletcher is agreeing, I'm just going to refer to Dr Hulse for the reasons I've given. A description of the damage which we've identified, and no marks at a higher level such as the bonnet or windscreen. And then under the heading causation of injuries, as your ladyship see in the second line, we are agreed that the majority of Felix Barrow's significant injuries were caused by the front of the car colliding with his left side. And then Dr Hulse, in the middle between the hole punches, line 2 and 3, Dr Hulse considers on the balance of probabilities the first point of contact between the car and Felix Barrow, which was his left arm and leg. And that's because otherwise he thinks he'd have died. And then new paragraph, Dr Hulse considers, due to lack of any wounds, evidence of wounds to head or face, his major head injury and fracture of the left mandible was caused by contact with a smooth, flat surface, such as the front bumper of the car. For this to have occurred, his head would have had to have been at a height similar to that shown in the diagram appended to his report, and that's the diagram appendix 3. And then if you kindly go over the page to page 85, under the heading left distal tibia and fibula, fracture, etc., you see before the 2 bullet points at the bottom, Dr Hulse considers these injuries were, on the balance probabilities, caused by the foot being run over by the front offside of the wheel. And then over the page again, under the heading left femur fracture, left elbow fracture, left knee injuries, Dr Hulse and Dr Fletcher agree these injuries were probably caused by a direct blow from the offside of the front of the Toyota Yaris. Then we have Dr Fletcher's evidence, which we can bypass because his evidence isn't before the court. And then if you drop down to the bottom, the last paragraph before the next indent, Dr Hulse considers on the balanced probabilities Felix was on his hands and knees or in a crouched position at the time of impact. The diagram attached to his report is to show the general position of the height of his head and torso relative to the front of the car. It's not intended to suggest the exact position of his limbs. And lady, I'm not hiding any other part of the evidence. I'm just very keen to keep moving. But that's in summary his first, the first joint statement. If you then kindly go to page 91, you'll see a supplementary report dated the 18th of January 2020 from Dr Hulse. And if you go over the page, or to page 94, at little Roman 4 under the heading My Opinion, and drop down into the first bullet point, given Dr Fletcher and I agree that part, if not all, of the head injuries came from contact with the front of the car, Felix Barrow's head had to be very low to make contact with the front of the car. And then over the page, little 6, taking into account this additional documentation, I consider my opinion as expressed in both my initial report and the joint statement remains unchanged. And then finally, the second joint statement starts at page 99. And by this stage, the joint accident reconstruction experts had raised the issue as to whether, rather than seeking to get up, the claimant was actually in the process of falling to the ground. And if you kindly go to page 102, at the top, Dr Hulse and Dr Fletcher agree the main issue to be resolved from a medical evidence perspective is whether Felix Barrow was in a crouch position and rising at the moment of collision, or if he was falling forward, assuming a stooped position. And then over the page, after reference to two diagrams, which I'll come back to, first one, as you know, is the Appendix 3 to Dr Hulse's original report. Second one I'll come to in a second. Dr Fletcher and Dr Hulse agree it's not possible to differentiate these hypotheses definitively on the basis of the injuries sustained. And then right at the end at page 105, last paragraph, Dr Hulse considers, in the light of subsequent evidence, the opinion contained in his original report remains unchanged. Now, my lady, what the contents of that second joint statement are important really only to this extent. It's suggested both by the judge, and I'll come to his judgment at paragraph 75 later. It's suggested by the judge and by my learned friend in his appeal skeleton argument at paragraph 52, I think it is, that there was some tremendous change to Dr Hulse's evidence in cross-examination. There wasn't. Because Dr Hulse recognised that his evidence was as to the position of the claimant at the moment of impact, not as to whether the claimant was positioned that way intending to go up or in the process of coming down. Does your ladyship have that submission, or should I?
I think if you take me to the judgment where you say this is
Yes, my lady.
incorrectly summarised.
In some ways, it's one of these wonderful, if it's a straw man or a detail, but it's where I could be sucked down a path that makes no odds to this appeal.
Well, you've made the submission, so I'd like to see where it
I
comes
know, my
from.
lady. I will show it to you now. The judgment at paragraph 75 is at page 78.
Thank
my lady.
you.
Para 75.
Yeah.
It might strike the neutral reader of the medical reports that the authors were seeking to proffer firm opinions on Felix's body position at the point of impact, that's correct, as in Dr Hulse was, and to derive from them conclusions as to whether he was running, slipping forwards or getting up. Now, I haven't taken to the evidence that shows he can't have been running at the point, but that's because he was in a crouched position, so he can't possibly have been running. The issue is whether he was slipping forward, so described, or getting up. And then it says, the judge says, it soon became apparent from the cross-examination of Dr Hulse that whatever the impression given in the reports, this was not the case. There is no impression in the reports. I've taken you to the reports. There is no impression.
Well, the judge is entitled to indicate that they made an impression upon him as to what Dr. Hulse was saying, but what you didn't do in taking us to the reports is to take us to a contrary position in the cross-examination of Dr. Hulse that the judge got wrong. He's saying that he takes into account the cross-examination.
No, my lady, that's because I've taken you to the second joint statement.
Yes, but this is cross-examination in court.
No, my lady, the effect of the cross-examination is set out in the passage below at paragraph 75.
Yes.
And that is where Dr. Hulse is recorded as saying, I can't be prescriptive about his absolute position. All I can say is he must have been low down enough not to go up over the bonnet, high enough up not to go down underneath the car. And then next little quote, I cannot say from his injuries what his body movement was at the time, whether he was stationary, falling, getting up. And I've taken you to the second joint statement in which Dr. Hulse is express in saying, that is not an issue that I can determine, and thereby made good my submission, my lady.
Right, well, I've got that submission. Yeah.
Yes, well, it's...
Mr. Weir, I'm not trying to be difficult, but I do want to follow your argument. So if I ask you to go to certain parts of the bundle,
of course, my lady.
It's to assist me in coming to a determination about your appeal.
My lady,
I'm
yes.
not being difficult.
My lady, I apologise if I've in any way sought to suggest inferentially that you...
Well, there we go.
My lady, paragraph 52 of my learned friend's skeleton argument is one I'm going to leave him to develop. It's at page 53.
Yes, of course.
So I don't want to use time in that straw man approach of answering an argument he raises that doesn't really matter. But I'll let him develop his submission that something special happened in cross-examination. First, it doesn't actually matter because the evidence of Dr. Hulse is the evidence of Dr. Hulse. But actually, he hasn't changed his evidence. His evidence has been throughout and remained following the second joint statement when this issue was put expressly to him, that he can't say whether the claimant was on the way up or on the way down. What he can tell you is he was in this low-down, crouched position at the point of collision.
So can I just ask a question?
Yes,
Forgive me, I'm sorry if it appears very naive. So in his judgment, whether or not reading it, you get the impression that the judge thinks that there is a difference. Does he misrecord the actual conclusion of Dr. Hulse?
No, my lady.
Right, okay, so what is the point of the submission? What are you saying?
That's why I prefixed it, my lady, with the submission that in one sense I'm going to something that doesn't matter, because it's ultimately what his evidence is. But a great deal of play is made of this by my learned friend.
All right.
It's the only the only point in which, in an entire skeleton argument, they seek to address our case in reference to the hard evidence is para 52. And the only point that's made in para 52 is the point I've just sought to dispose of.
All right.
That's all, my ladies. The figure, the photograph, which was in the second joint statement, also, as your ladyship will recall, appears in the judgment.
Yes.
And that's at page 79. And again, it's a matter of fact, not in dispute. And that is a photograph of Mr. Sorton's son, who was 144 centimetres tall at the time of the photograph. And the claimant was 147 centimetres tall, and the reference for that is supplemental bundle page 41 as part of Dr. Hulse's first report. So in other words, 3 centimetres difference if the court needs to have a sense of quite what a low down crouch position is necessary in order only to cause damage to the lower part of the car. That is a helpful photograph. That is what is meant by low down crouch position. Well, lady, that was just all in support of what is the hard evidence. What the hard evidence establishes is that the claimant was in that position, by which I mean sometimes I'll say broadly, because Dr. Hulse very properly recognised that he can't say precisely where, for instance, looking at the the figure 4 in the photograph at page 79 of the core bundle, precisely whether it was one or t'other. But what's critical is the claimant had to be low down with his head low enough, which means his back has to come to the horizontal, as you see in both photographs, with his knee and forward and his foot still in line with the car. Left foot, because his left foot is run over. In other words, not in say, a Superman position. Arms forward, legs far behind you, diving into a pool. Those who have the skill to perform those, execute those sorts of good dives into a pool. Nothing like that, because within that short area of damage to the car, it's managed to run over his left foot and fracture his left femur, his left tibia, fibula, his left elbow, and strike his head, hence crouched. And I then turn, my lady, to our second submission, which is what actually was the core issue at trial. And can I start for these purposes with the particulars of claim, please, and ask the court to go to page 98 of the core bundle. Your ladyship will see from paragraphs 14 to 16 the case as pleaded, which is indeed the claimant's case. So he crossed at a fast walk, slipped when he'd reached, I'm reading from para 14, roughly the middle of the road, fell backwards onto the bottom, and then leaping to para 16 for the movement of the claimant. As he was getting up from the floor and was leaning forward, still in the process of doing so, he was struck on his left side by the defendant's vehicle. The defence, if you can kindly go to page 111, paragraph 8, just before little 1, the defendants say that the true circumstances of the collision were as follows. And then if you go over the page, please, down to little 6. And you can scan read, if you kindly will, little 6 until you get to the bottom part, which says the first defendant, the first claimant from behind the offside vehicle, ran into the path of the first defendant's Toyota, colliding with the front offside of her Toyota. There's no mention in the defence of the appellant falling forward shortly prior to the collision, let alone of him falling forward sufficiently to get into the crouched position which he evidently must have been in, only that he was running into the path of the car. So when then introducing the hard evidence as to body position, the appellant or claimant must have been low to the ground, with his body and head parallel to the ground, with his left side, including his left foot, exposed to the oncoming lower section of the car because they were directly hit by the lower section of the car. In other words, in a crouched position. And that being so, and the court armed with incontrovertible evidence as to the claimant's body position, needed only to decide one issue, if we're looking at core issue. Namely, was the claimant in this crouched position, having previously fallen to the ground, towards the ground, was the claimant in this crouched position having previously fallen to the ground and in the process of trying to get up, the claimant's case, or, as per the defendant's trial case, and we say properly hypothesis or theory, not their pleaded case, and not the evidence of any witness called by the defendant, was the appellant actually in the process of falling over so far that he'd reached this crouched position by the time of collision with the car? That was the core issue. He was in that crouched position. Was he in the crouched position as per Nicholas's evidence because he'd fallen onto his bottom, was in the process of getting up? Or, and it's a theory only, had he fallen so far towards the ground as to get into that position when he was actually struck by the car? Now, I now turn, my lady, to how the judge chose to approach determining liability in this case. And can I invite the court first to the judgment of paragraph 3, which is page 65. Page 65 is the core bundle, my lady. Although the court was presented with a considerable amount of expert evidence, it soon became apparent that the core dispute really turned upon two closely related core questions of fact, namely, 1, was Felix running or walking across the road immediately prior to the collision? 2, what was Felix's likely body position at the time of impact? Can I take those in turn, my lady? So the first core issue identified by the judge. The difficulty with that issue is that on the appellant's case, he was neither walking nor running immediately prior to the collision. Doesn't touch our case. He had walked across the road, he had fallen over, he was trying to get up. Even if he'd run across the road, it's common ground that that would only go to contributory negligence. If he'd run across the road, fallen on his bottom, and was in the process of getting up. And the second core issue, my lady, if you see what was Felix's likely body position at the time of impact, has been answered by the hard evidence. His position at the time of impact was that of being in a crouched position, such that his left foot was able to be driven over by a front offside wheel of the car, and all those parts of his body were struck by the low-down offside part of the car. So that issue was answered by the hard evidence. So the question wasn't what was his body position at the time of impact. The issue was whether he was in the process of getting up or falling down. And that is a significant error when the learned judge has chosen, he's in control of his judgment, has chosen right at the outset of the judgment to say, these are the core issues that I need to decide. Can I then set out how the judge proceeded to approach the issue of liability in the case? First, by reference to his observations on the law.
Well, just before you do that, Mr. Weir, don't the questions posed in paragraph 3 have to be read in the context of the judge's summary in paragraphs 5 and 6 of the claimant's answer to the questions and the defendant's answer to the questions?
Well, Lady, absolutely. They have to be read in context. But you can't read in context a question, what was Felix's likely body position at the time of impact, in an articulate, lengthy and detailed judgment to mean other than what it says on its face. And that question was answered.
But the judge clearly understood that the claimant's case was that Felix was walking across the road and slipped backwards. It took him several seconds to start getting to his feet, and he was then hit by the car. And he goes on to say, defendants accepted if this version of events is correct, then the claimant is bound to succeed. So what's wrong with that?
Lady, paragraph 3, yes, it has to be read in context. It's also written in clear terms, and it is not identifying the core issue. It's identifying an issue that is agreed. It is an incontrovertible fact, his likely body position at the time of impact, and it's asking another question, whether he's running or walking immediately prior to the accident. It is not an appropriate question by way of core issue. If that's of little concern to the court, the two issues identified as core issues.
But I'm just trying to understand whether it really matters if it's clear from paragraph 5, as as it appears to be because you're not disagreeing with his proposition, that the judge well understood what the claimant's case was.
Well, my lady, that rather depends on the degree of benevolence when one looks at the judgment in the round that this court may, and in our submission would need, consistently to apply against the claimant and in favour of the judgment. If one consistently chooses to apply the most benevolent approach to the description given by the judge, not given by us, it's given by the judge.
I think my lady asked you a simple question. Now, you've given that caveat. So what's the answer to my lady? Do you agree that paragraph 5 accurately summarises Felix's case before the court? Below.
My lady, yes and no. Yes, it describes the claimant's case, which we see from the particulars of claim. No, it's not sufficient because it's identifying it in a context where the judge is already looking at the wrong target.
If paragraph 3, little 2, had said what was Felix's likely body position at the time of impact and how did he get there, would you accept that that would be accurate?
Well, my lord, the issue, what was likely position, was answered. So to describe as a core issue to be determined, he says, paragraph 3, the core dispute turns upon 2 closely related core questions of fact. So no, I do not describe that as accurate because those are resolved. That's not a core dispute. It's understanding, really understanding, that that is not an issue which has bedeviled this judgment. So yes, says paragraph 5 saying this is the claimant's case, but no, because he's starting always from the wrong place. He's treating that as a disputed issue. So if it said, and this is our description of the core issue, if it said, was Felix in the process of going upwards or down when the collision occurred, that would be the core issue. So the second part of that, but the first part is not a disputed fact. And that's rather our point.
Well, part of your case, and you're going to develop it, is the significance of the word crouching. But it seems to me that what emerges clearly from Dr. Hulse's evidence, and is perhaps not in dispute, is that Felix wasn't standing up. He wasn't totally vertical when he was hit, because otherwise the injuries would not be as they are. He was hit when his head and the rest of him was quite low down. But even if figure 4 at paragraph 66 were a photo, which of course it isn't,
yes,
of what happened, the question is, has, in this case, Mr. Salton's son, but has the boy depicted reached that position by falling forward or by getting up?
Yes, my lord. That is the core issue.
Yes.
Absolutely. That's it. And if the judge had said that, he'd be tracking the case in the appropriate fashion, but he hasn't had to say that.
So you're now going on to say why, having not said that, that when he deals with it, I don't quite understand what you mean by tracking, and I do want to know what you mean by tracking the wrong evidence, as it were.
Yes, my lady. It's because he failed to acknowledge and apply that hard evidence. It's not just not in a vertical position, but if you read Judgment 75 and out of context, the answer of Dr. Hulse, I can't say he was on the ground and I can't say he was standing up. It's not that. It's actually he has to have been what I would describe as very low to the ground, because we can see that from the damage to the vehicle and the evidence of Dr. Hulse as to likely body position as depicted at paragraph 76 of the judgment. It's not even sort of quite low or leaning forwards. It's very low to the ground because you've got to be low enough to get your head struck by the front of the car. You've also got to be compressed enough to get all parts of your body, the head, the elbow, the femur, the tibia, and your foot run over, and all in a small space of offside damage to the car. We see that in going back to figure 3 at page 69. If you look at page 69, it's a very compressed body position and very low down. Not, we say, in any way consistent with the person falling forwards, and entirely consistent with the person in a crouch position getting off the floor. And had the judge grasped that, this is the tracking part, he would have recognised the centrality of that hard evidence, and he would have tested the witness evidence of fact expressly against it. I'll come to show.
But he's still got to determine, hasn't he, whether this crouch position was getting up or going down.
Absolutely.
Yes. So when he's tracking the evidence, as you say, on
Yes,
that
ma'am.
basis, it would certainly help me for you to indicate how he should have approached it in terms,
Yes, my lady.
not just say he approached it in the
No, my
wrong
lady.
way.
That's part of my later submissions. I can rush them now, or I can just take you through. I'd rather take you through.
All right, well, we see what's coming. You've given us a taster of what's to come. Right.
Yes, my lady, but
Yeah.
the headings that I gave should give
Yes,
us
I've got the
steer
headings.
because it was
Yes,
it's
I've got
his
the
failure
headings.
to apply the hard evidence, and I'm going to go through each witness in turn.
Yeah, okay.
So that is exactly what I intend to do, my lady.
And that's your heading number 5, how judge failed
Yes,
to
my,
accept
yes, my lady.
or apply the hard evidences. How he failed to accept, you say, at number 5, and how he failed to apply was number 6.
Well, apologies, then it's 6, not 5. But yes,
Yeah, okay.
they link up.
Yeah, okay.
Absolutely. Yes, that's when I take you through what I call
All right.
tracking.
Yeah.
So, my lady, at this point I was just going to effectively, if you like, introduce with some submissions how the judge reached his conclusion, if you like, in broad stages.
Yeah.
Because obviously the court's had the opportunity to read with care the judgment, but I just want to do it in this way, if I may. If you then go to page 70 of the core bundle, you're at paragraph 27 and following, under a heading Road Traffic Accidents, the Law.
Yeah.
And you'll see that para 27, the end, with 2 well-known cases, do however illustrate how the court calibrates what the standard of a reasonable driver is. He then references Lord Justice Latham in a case called Lunton Khalifa, that a car is potentially a dangerous weapon, and observes, this means those driving cars owe clear duties of care to those around them. That's a description of an existence of a duty of care which is owed by everyone on the road. It's owed by a pedestrian to a road user, by a cyclist to a road user, a cyclist to a pedestrian, and so on and so forth. Completely misses the point. If you actually go to Lunton Khalifa, which is in the authorities bundle.
Grey, I am going to interrupt you. I mean, that's all jolly well, but does any of the judge's reasoning turn on his approach to the law, whether or not that's correct? Because surely what the judge was doing in paragraphs 5 and 6 was saying, the parties agree that if I decide the case, the facts are X, then the claimant succeeds, and if I decide the facts are Y, the defendant succeeds. So why does it matter if he got the law wrong?
Well, lady, I well understand that observation and the force of it. At the same time, this is a judgment in which, as I've sought to submit, the judge has repeatedly adopted a very favourable approach to drivers. And we'll see this when we come to the plausibility theory. And if the judge, again, has set off from the wrong place by failing to recognise, in this context, the high burden placed upon a driver, that is a matter of concern. So this may be a cumulative concern as opposed to a direct application of a standard in circumstances where there's common ground. If scenario A, claimant wins. If scenario B,
But I'm sorry, I just don't understand the submission.
Well,
Maybe
lady,
I'll just have to leave it.
I would hope that the court would take the view, and as I say, this echoes the submission I've made before. If this court wishes to say, well, the learned judge identified core issues wrongly, but let's not trouble, because in paragraph 5 he sets out the claimant's case. The learned judge identified a standard of care wrongly, but let's not trouble, because standard of care doesn't really matter in this
But
case.
did he?
And so we carry on. That
Did
should...
he, Mr. Weir? I mean, what's wrong with paragraphs 27 to 29?
It's 28, my lord, and it's simply this. If you go to page 6 of the authorities bundle, paragraph 20, sidebarred, 4 lines down, but nonetheless, bearing in mind, does the court have that?
Yes.
Bearing in mind that the fact that this court has consistently imposed on the drivers of cars a high burden to reflect the fact that the car is potentially a dangerous weapon. That's what it's about. It's about a high burden, or otherwise I would describe as an exacting standard upon a driver, not least in circumstances where there is a child, as here, seen on the pavement. What we get instead is simply the description, if you go back to paragraph 28, a car is potentially a dangerous weapon, so drivers owe clear duties to care to those around them. Not a description of the high burden at all. Next,
Do you dispute paragraph 29, what Lord Justice Laws says?
my lord, I would struggle to dispute what Lord Justice Law says, and I know it's been referenced multiple occasions.
Yeah.
My lady, the judge considered he was not assisted by expert evidence when assessing the conflicting witness of fact evidence. And that's clear from multiple paragraphs in his judgment, starting with paragraph 8 on page 66. I'm going to try to do these at a trot, if I may, my lady. At 8, you'll see towards the bottom there was little hard evidence, such as extensive damage to the car, that would enable ready reconstruction. Felix's physical injuries in themselves do not provide clear answers to the core questions. Obviously, we say is simply not right. Paragraph 35, page 71, my lady. And it's of a length where I'm going to invite the court simply to read para 35, if that's okay. Next, paragraph 72, my lady, which is at page 77. Ladyship have that, page 77, para 72 at the bottom, when he says, and the very limited extent to which conclusions could be drawn on body position at the time of impact, including whether it was running, walking, slipping, or in the process of getting up. Well, he couldn't have been running and he couldn't have been walking. He's either going down and all the way almost to the ground, or he's coming up. But he was not running when he was hit. He was not walking when he was hit.
Isn't the question of whether or not Felix was walking or running before the crouch important? Because that will flavour, will it not, the evidence as to whether or not it's likely or probable that if he was running, it's probable that he slipped. If he was walking and fell and got up. I mean, isn't that an important question for the judge to... I appreciate what you say, and of course, he wasn't running at the time of the collision, but immediately before the crouch position, whatever caused falling down or getting up, isn't that an important question?
Well, is it a question before the court? Yeah. yes, it's a question for what
But it was a
happened.
question that the judge thought was important.
I understand, my lady, but is it a question before the court? Yes. Is it a core question? No. But does it go to part of the assessment of the factual dispute? Yes. But what is the appropriate way to test a witness evidence I'm going to come to, which is by reference to the incontrovertible fact evidence, first and foremost. That's not the approach at all of the judge. So again, we get this when we go to the findings and conclusion.
All right. Okay. And that's where you're taking us now?
My lady, yes. Page 84, paragraph 102.
Thank you.
So in reaching this finding, I've relied primarily on my assessment of the lay witness evidence examined in the context of the road layout. It's very clear that's what he's doing. He's saying I essentially have a contest of fact. The expert evidence doesn't really take me anywhere, and now I'm going to assess the conflict of factual evidence. He then makes his finding, that's actually same page, paragraph 101. So he makes the finding, as your ladyship will see, para 101. The most probable series of events is Felix ran across the road. He did so after the vehicle had just passed in front from his left, obscuring him from Mrs. Merrett's vision. He probably slipped and his body fell into the path of Mrs. Merrett's car. So he made a positive finding that the appellant slipped forward, though based on no evidence given at court. And although not stated in these terms, it must include a positive finding to be consistent with the hard evidence that he'd fallen far enough to be in the very low down position, crouched position, as shown by Dr Hulse in the two diagrams, diagram and photograph, at the point of collision. Again, based upon evidence that no one gave at trial.
Is it right to say he did so after a vehicle had just passed him from his left?
Yeah, that my learned friend in this Scalise's argument recognises that that's a mistake, and your lordship has identified it as from his right. So what he's made is positive finding that slipped forwards, his description, no one else's. And he says body fell into the path, but to be consistent with the hard evidence, that must be into a crouched position, very low to the ground, in order to sustain damage that we know the claimant did sustain compared to the damage to the vehicle. And his reasoning came in essentially, I would describe it as 4 parts. First, he relied on what I call the plausibility assumption in favour of the respondent. And that you can pick up at judgment at paragraphs 103 and 104. It's his first reason at 103 that starts, well, certainly possible, I consider it unlikely Mrs. Merrett would have driven along the stretch of Hillpan Road, which afforded good vision of the road ahead, without seeing Felix in the middle of the road, if he'd walked across the road, or even if he'd run, fallen, and tried to get back to his feet. And at para 104, she also applies that to the evidence of Mr. Gent. You see right in the middle of 104, your ladyship might pick up, I consider it improbable. Your ladyship see that right in the middle of 104. Improbable that Felix could have been on the ground in the centre of the road for several seconds without either Mrs. Merrett or Mr. Gent noticing his presence. That's what I call the plausibility assumption in favour of drivers. And that's where we see the cumulative effect of his approach to a standard of care, his misidentification of core issues and so forth. That's a part of the trouble with his judgment. If at each time he's to be forgiven, and that's always consider this in the round.
He does say at paragraph 104 that he accepts it's possible the defendant could have been distracted or driving dangerously, and had the only evidence for the defendant being the defendant's evidence, it would have been a much more difficult case to decide.
Yes, my lady.
So he does acknowledge the possibility that the defendant was driving negligently. He's looking at the evidence piece by piece.
My lady, why can't it be said in a pedestrian car strike, pedestrians don't go into the path of cars? What's wrong with that as a plausibility theory? Where does one get when one starts on the basis this accident hasn't happened?
Mr. Weir, we know that boys sometimes do run out into the road. I'm not saying that's what happened here, but it was apparent. Both my sons.
My lady, road traffic litigation would not function if instead of recognising the strict standard or high burden identified by Lord Justice Latham on car drivers, one started on the premise car drivers would see if someone's messing about in the road in front of them, those accidents don't happen in that way, and we all know that children go into the path of cars. That is judge and jury. It's all over by that stage. We've got a presumption against the claimant, and that is antithetical to the proper approach, we say, to road traffic litigation.
That wasn't the judge's approach.
Why? My lady, where does he say in terms, I take into account that one wouldn't expect a person of whatever age to run out into the path of a car? If this is now the starting point for analysis of road traffic litigation, it's a dark day for claimants.
Well, you're right about that, Mr. Weir, but it doesn't seem to me that that's what the judge said. I mean, as I read paragraph 104, he is almost saying that if Mr. Gent had never existed, the claimant would have proved his case. But he certainly regards, anyway, he says the conclusion would have been much more difficult to reach. But he regards Mr. Gent as decisive because he would first the grey vehicle classes, and then on any view, Felix crosses the road.
Not on any view, not on the claimant's case. No. We set this out in our skeleton arguments, and I can come back to it later.
Well, perhaps you'd better deal with it now. I'm sorry, I've obviously misunderstood the
Well,
case. I thought
Yes,
that the first A vehicle driver never stopped, and why should they, goes past, and then Felix starts to cross the road, and the next vehicle coming is Mr. Gent. Is that wrong?
Well, right or wrong, it's a question of that's how the judge analysed the evidence. So that's an accurate description of the judgment. If you kindly go back to our skeleton argument. It's paragraphs 50 and 51, page 30. Can I invite the court kindly to reread those two paragraphs? There is a body of evidence, I'm not saying it's the only evidence because it was mixed evidence in relation to this issue. There was a body of evidence to suggest that what actually happened is that the claimant went out into the road, fell, the grey car passed him, and he came into view of Mr. Gent in a split second before the accident, which is exactly how his evidence is described as being in a very short window of time. And so it's not the case that Mr. Gent had an unobscured view south down the road throughout effectively the whole business of the claimant being on the road. And that evidence, which is why we complain at paras 50 to 51 again, was not analysed or addressed by the judge.
Well, doesn't he address it by referring to Mr. Gent's evidence, which he accepts, was that he first saw Felix running across the road, not in it.
Oh. Once one's reached a conclusion that one's accepting Mr. Gent's evidence, this is why my you may say ambivalent answer to your question was, is it an issue whether he was running or walking? Because once you've accepted Mr. Gent's evidence, you have his evidence in toto, which is that this happened from pavement to accident in a run. And so it flows. But this is all a prelude to the factual determination. It's no good saying once one has Mr. Gent's evidence, it's was the judge entitled to conclude.
I understand that, Mr. Weir, but you pose the question that the judge does not, or pose the submission, the judge does not address the point.
Yes, my lady.
My question, and I'm trying to understand your submissions, and I may be being very slow and
that won't be
all
the case,
the rest
my
of
lady.
it.
It is my fault.
But you do understand, Mr. Weir, that these challenges that we make are in order to test the case.
Yes, my lady.
We're not doing it to indicate any preformed views. We want to challenge you so that you've got the merit, as it were, of where our thoughts are and what you need to address.
Yes, my lady.
And you're being quite defensive on
My
occasions.
I'm not sure.
All right, so
Something is not working, and from this end, I apologise.
no, not at all. It's just that I don't want you to think that you need to be so defensive all the time, and challenge us in an almost a provocative way of saying, well, you know, why are you being so benevolent to the judge? We're not. We're trying to understand your case.
My lady, the case is the issue before the court was to determine whether the claimant was coming up or going
Yes,
down.
I know that.
My lady, yes.
That was just a general comment, Mr. Weir, to try and get us on.
Sorry, my lady. I was trying to address the issue of does the judge need to? Of course the judge needs to, because he's testing the evidence of the witnesses. That's what he needs to do. In order to test that evidence, he needs to say, I've heard evidence about the path cards, but I don't accept it. He hasn't. He's just simply gone for Mr. Gent was an impressive witness. And I'm trying to show you the steps he's taken. That's the part of this submission that I'm going through. And I've tried to show you, trying to take a route, a sort of shorthand route, if you like, through his analysis. And I readily recognise the force if we are now to put Mrs. Merrett to one side, because in para 104, 4 or 5 lines down, he says, the key reason why I consider Nicholas's account unreliable is the corroboration provided by Mr. Gent. So absolutely, it's Mr. Gent who's critical, but when one goes over to para 108, last sentence, the evidence, that's of Nicholas, is inconsistent with that of Mr. Gent, Mrs. Merrett, and with his initial account. So he does put Mrs. Merrett into the pot, if I can put it that way, or into the balancing exercise. And he does so having given the plausibility theory a run, with which we complain. And that is why. And he makes that assessment that Nicholas's evidence is inconsistent, whilst finding, para 109, second and third lines, that Nicholas struck him as an articulate and intelligent young man seeking to do his best to recall, and Mrs. Stannard, more than halfway through para 109, to be an entirely honest witness. So it's 2/3 of the way through para 109. So he hasn't rejected that evidence on the basis that he has the advantage over this court and he's seen them in the witness box, and he is not impressed by the quality of their evidence. But what he's done instead, we'll see, but we can see it, we can go to it now. If you look at para 109 now, and I'll come back to all of this. So in para 109, after he says Nicholas struck me as an articulate, intelligent young man, etc., he says his evidence to the court would have been one of very many occasions on which he was asked to recount what occurred, and he would have been under no doubt of the significance of it in Felix's case. I consider the disparity between what occurred and what he later recalled is best explained by many of the factors identified in Guestman as capable of degrading the quality of recall. And I'm going to come back to that because it's critical on this appeal. So as far as he's concerned, we have an initial account, which is the account of PC Giles, as to what PC Giles says Nicholas told PC Giles, and everything later than that is guessmin, poor quality of recall, much later down the line. That's his analysis. That's the basis upon which he rejects the evidence of Nicholas.
Sorry to interrupt your flow, but I was asking about Mr. Gent a moment ago, and the judge records at 65 to 70 the evidence that Mr. Gent gave and what he said in cross-examination. And 67, he, Gent, stated that after a grey car ahead of him passed a driveway, a boy ran from his left towards the middle of the road. And it's put to him at paragraph 70 that his memory was playing tricks and so forth, and his mind was filling in the gaps, and Mr. Gent maintained under cross-examination he saw Felix run out from his drive. Now, you're saying that on a proper application of guessmin and so on, the judge should have said that is all inconsistent with the expert evidence of Dr. Hulse, therefore I must reject it. Mr. Gent has got it completely wrong.
Well, not about the grey car, in the sense of it got it completely wrong in relation to his critical description of the claimant, and ergo other parts must fall. Yes, my lord. But my complaint to track this back is that before the judge decides, am I going to prefer the evidence of Mr. Gent, let's focus on Mr. Gent and leave Mrs. Merrett just for the moment, Mr. Gent against Nicholas, the judge has applied a plausibility theory. Well, I'm minded to like the evidence of Mr. Gent because a boy in a road for a very long time is not someone who's going to be missed by a driver. But in order to make that determination, you've got to know whether Mr. Gent had a clear and unobstructed view throughout his trip down. In order to make that assessment, you've got to decide whether you prefer the evidence of Mr. Gent to that of Nicholas. So you can't start from this presumption because the two are tied together. It's an unfair presumption in favour of Mr. Gent when there's evidence out there that says he doesn't have a clear and unobstructed view. So there is an obvious explanation as to why it is that a boy has been out in the road and he's not seen him. What you've done is then applying the presumption, of course, you then find yourself favouring the evidence of Mr. Gent.
But may I just ask this? If the judge had approached the conflict in the evidence between Nicholas and Mr. Gent in the way you suggest he should, without the plausibility theory background, he's got two very different accounts, obviously. And so he's got to say, well, what else is there? And we know that there's PC Giles that gives an indication of what PC Giles said Nicholas first said. And that, the judge found, was supportive to some extent of part of Mr. Gent's evidence. Now, we are looking at it very much in silos, Mr. Gent, Nicholas, but there was support for Mr. Gent's evidence, wasn't there, in some respects? If one takes PC Giles' evidence as being preferred by the judge to that of Nicholas and Mrs. Stannard as to what they did or didn't say, and the reliability that the judge says of that evidence, of the first impressions. Do you agree with that proposition? Not put simply in that way, no, because that goes back to the heart of the case,
And first of all, to echo, if I may, the observation your ladyship's made by way of submission, it's critical to remember that at all stages, if you like, all the balls have been juggled in the air before a decision is made. So it's, as your ladyship rightly says, we can't put them into the silos. And the problem is, when the balls are in the air, matters are being predetermined without regard to the proper mechanism for assessing the evidence. And the proper mechanism for assessing the evidence, which is in the next stage of my submission,
All right.
is to test that evidence against uncontroverted fact.
I quite appreciate there's a controversy as between running and walking, as between slipping, but just boringly going back to the question of whether Mr. Gent had an unobstructive view, is there any evidence that he didn't?
My Lord, it's the evidence that we've set out at Powers 1551. There was evidence before the court as to the movement of vehicles, which would indicate that the grey car came through after the claimant had gone out into the road, hence it's flashing its lights at the oncoming traffic. That was the evidence Mr. Hardacre that was before the court. We've sought to say to set it out at Powers 50 to 51.
Yes.
We don't have the grey car witness. The grey car witness drove off.
Yes.
So the grey car witness is ahead of Mr. Gent. The question is whether at the time that the grey car passes the claimant is A, on the pavement, or B, in the middle of the road.
Well, or has got into the road. I mean, it couldn't have been in the middle of the road, or the grey car would have had to swerve and things would have been very different.
Well, my lord, no. All we know from the grey car is he's flashed his lights and he's gone past and gone off.
Yes.
And the description that's always been given of the claimant falling to the ground is in the middle of the road.
Yes.
There's no need for a car. I mean, it's not a manoeuvre one would in any way recommend. It's not what should happen. But again, this is all part of things that do happen in reality with drivers on roads as well as pedestrians. This is just part of what goes on out in the real world, which isn't based upon plausibility theories. It's based upon the evidence that's adduced. And there's nothing at all to say that grey car did not go past the claimant when he was in the middle of the road, unless one says, I accept the evidence of Mr. Gent. But this is the issue. Does one?
Was there any injury to Felix's right foot or lower leg?
No, my lady.
No.
My lady, in terms of the proper approach, this is my submission 4, to the determination of factual conflict between witnesses. We can start with the learned judge at paragraph 9, page 66. Second sentence, it looks at the evidence in its totality. It seeks to understand the relevant layout of the scene, identify any objective facts that might act as lodestars by which more subjective opinion and recollection can be tested. And he says much the same at paragraph 33 at page 71. When he agrees with Ms. Rodway's submission, when addressed the observation that the objective evidence is always an extremely helpful source, both in itself and as a guide to calibrating the recollection of witnesses. And we say that's exactly right, and it is of a piece with the case of Martin and Kogan, which we have in the bundle at paragraph 88, in its authorities bundle, page 91. I'll ask you please to turn up. Starts at page 90, referencing the Guestman case, and the Court of Appeal opened the page, paragraph 88 still sidebarred. I think the court can see page 91 of the authorities bundle. picking it up about 5 lines down. It's one of a line of distinguished judicial observations that emphasise the fallibility of human memory and the need to assess witness evidence in its proper place alongside contemporaneous documentary evidence and evidence upon which undoubted or probable reliance can be placed. And then you see reference, I would describe as approvingly, to the article or essay by Lord Bingham, the judge and juror, and we've included that in the bundle. And there are just 2 passages in that, if I can kindly take you to them. Starts at page 189. And the court will see the second new paragraph starts. The normal first step in resolving issues of primary facts. Your Ladyship have that?
Yes.
Is, I feel sure, to add to what's common ground between the parties, which the pleadings in the action should have identified but often do not, such facts as are shown to be incontrovertible. And then over the page, page 190, in the middle, just before the list, I think the following, although their relative importance will vary widely from case to case. So the main tests needed to determine whether a witness is lying or not are, I think, the following, although their relative importance will vary widely from case to case. 1, the consistency of the witness's evidence with what is agreed or clearly shown by other evidence to have occurred. And then after the list, the first 3 of these tests may in general be regarded as giving a useful pointer to where the truth lies. Now that's put on a truth or lying basis, but it's equally valid in our submission in relation to determination of a factual dispute such as this one, when the judge has made no findings in relation to any party lying. So
it's all, these first 3 points are all about consistency.
my lady, they're about consistency because you have consistency over time, but you also have consistency with hard evidence.
Yes, I understand that.
Sorry.
But it's consistency which the judge deals with in some respects by reference to different accounts throughout the course of the proceedings. And as I think you've already referred to this, Mr. Weir, but obviously we also have to be aware that credibility does not necessarily indicate accuracy. They are 2 different things. Credibility and reliability sometimes are intermingled, but a credible witness can be mistaken.
Well, absolutely, my lady. It's part of the guidance that we obtain from Guestman amongst other cases.
Yes, of course, but yeah. So
it's part of the difficulty we say when the learned judge simply says, having identified Guestman, gone through Guestman in his judgment, and then says Mr. Gent's an impressive witness.
yes, of course, but the essay that you've referred us to.
Is it an error of law to say that Mr. Gent is an impressive witness?
I don't wish to elevate it to that level of say it's an error of law to say he's an impressive witness. We can say he's an impressive witness. One has to remember that the most helpful assessment is not going to come from saying he's impressive, because in echo of the observation of my lady, because that sounds like saying he comes across as a credible witness, which isn't really where we go. Well,
it could be that the judge used a shorthand for he's credible and accurate, in my view. I mean, that's why I'm saying there is a difference, isn't there? And in Nicholas's case, the judge was at pains to say, I think he's an honest witness, he's not deliberately lying to me. But there are all these reasons why his account has changed.
Well, my lady, all these reasons why reduced to Guestman basis of his quality of his recall has diminished as a passage
And the
of time.
degrading. Yeah.
Yes, that's what it reduces
Well,
to.
it's not just that. It's that he gave the judge found he gave a different account to PC Giles immediately after the accident.
Well, my lady, that goes to the Nicholas evidence, which I want to deal with in one go rather than piecemeal, if I may. So if I'll be forgiven, I'm just going to make a further submission and then get to the Nicholas evidence. give you our case in full in relation to that. The precursor stage I was at was my fifth submission, which was how the judge failed to understand the significance of the hard evidence on body position. Now, we would say that much is clear from the passages of the judgments that I've already taken the court to, when, as I've sought to show, the judge says, well, really, this is just an assessment of conflicting witness evidence of fact. And I've taken you to the judgment at paragraph 75, and the difficulty with paragraph 75 is that the judge has clearly misunderstood, although he sets out accurately enough what Dr Hulse has said in cross-examination. He's misunderstood that Dr Hulse didn't change his opinion and was consistent throughout in his opinion that the claimant must have been in a low-down, crouched position at the point of collision. And we see this because by the time we get to the actual reasoning, if you go to page 87, paragraph 113, all that the judge says, if you go to the second sentence, firstly, save for the fact that Felix's head and torso were likely in a forward position as shown by both images above, that's his reference to the figure 4 in the photograph, Dr Hulse was at pains to point out that medical science couldn't determine whether he was falling forwards or trying to stand up at the time of impact. The difficulty with that is all he describes Dr Hulse as assisting the court in relation to is that his head and torso were in a forward position. But he doesn't. Dr Hulse describes how the claimant must have been so low to the ground. In the crouch position, his left foot being run over, and all those parts of his body being struck by the low part of the car.
But is the judge there referring to, when he talks about refers to the image, both images above, is he referring to figure 4?
I do believe so, my lady.
Well, so why does he need to say all of that if there you've got the pictures showing precisely that position?
Well, Lady, I can't speak for the learned judge as to why he's described, as why he's chosen to refer back, but he's addressing, as you see at para 112, the claimant's case that you don't fall forwards into that crouched position. You fall forwards like the diver. You fall forwards so that your arms go away from your leg. Your body elongates, if I can put it that way. That's how one falls forwards. You fall forwards, splaying out. It's completely different from ending up in a crouched position. And this, whilst rejected by the judge, is frankly a matter in which this court is equally well placed to make its own assessment. But by the time we get to the discussion and reasoning section, the learned judge is not describing how the claimant must have been in this crouched, compressed position. He's just saying, Dr Hulse is saying, head and torso were in a forward position.
And referring back to the pictures.
Yes, my lady. I believe those are a reference back to page 79, paragraph 76. And then nowhere does the judge finally say, using his own language, that objective evidence operates as a lodestar or such similar language, but that was his description. We just don't get any part of his judgment in which he says, this objective evidence provides a lodestar or a guide against which I can test the reliability of the conflicting witness evidence, which is exactly, we say, what he needed to do. Can I then turn to the witness evidence?
Maybe he didn't think it was.
My lady, that is exactly how it would appear. He did not think it was, and he should have done.
I see.
That is the kernel of the appeal. So can I now turn to how the judge failed to apply the hard evidence, first in relation to the evidence of Nicholas? And can I start not with PC Giles' evidence, which I'll come to, but with the evidence that Nicholas gave, albeit second-hand, but there's no disputing that this was an accurate second-hand description, in November 2015. And that evidence you can actually see if you kindly go to the supplemental bundle on page 20. Here you're in PC Giles's notes or records, and the page before, page 19 down the bottom. So we're at pages 19 to 20, my lady, of the supplemental bundle. Down at the bottom you'll see report time, right hand column, 30th of November 2015. And then if you kindly go over the page, you'll see at the top, telephone call with Hugh Barrow. He stated he'd spoken with Jane Stannard, mother of Nicholas. He's now said Felix had walked across the road and then slipped. He was then getting up before he was hit by the vehicle. And then PC Giles continues, this is in stark contrast to the account he initially gave and that of the witnesses. As I say, there's no dispute that that is evidence that Nicholas gave, albeit via Hugh Barrow, to PC Giles in November 2015. And what I would ask the court to note is as follows. First, that evidence is consistent with the hard evidence. It is the only witness evidence of a piece with the hard evidence, unless you take Mrs. Merrett's description in her witness statement that the claimant was in a crouched position. And secondly, it's evidence from which Nicholas did not waver. And that is all the way up to and including the trial process, when aged 15, he was cross-examined by my learned friend. And thirdly, that evidence was given within 2 months of the accident. 7th of October 2015 was the accident, and this was the 30th of November 2015. Not to say he didn't have that evidence to give before the 30th of November 15, that's just when Hugh Barrow spoke to PC Gent. But even if it is taken as of the 30th of November 2015, that is evidence within 2 months of the accident, long before the hard evidence materialised from Dr Hulse. Long before. There was no hard evidence available. This was just the evidence of the young lad who'd witnessed his friend being hit. And rather than that being a key point in the claimant's favour, nowhere does the judge acknowledge or attach weight, any weight, to Nicholas having given this evidence, A, long ago, and B, long before the expert evidence came out to show that the claimant must have been in a crouched position, low to the ground, when he was hit.
What's the significance that the judge gave to what's said on page 13 of the same bundle in PC Giles's log? I think it's PC Giles's log.
It is, my lord.
What Nicholas is said to have said on the day.
What Nicholas is said to have said on the day is page 7. And this is the record of PC Gent. And it's actually...
PC Giles.
I'm sorry, I keep calling him PC Giles. And it's actually quite easy to read, or at least the relevant part. Right at the bottom, the court see Nicholas said, "Wait, there's a car," then ran across road, slipped and hit car. That's what that says. I think, is that what my lord's...
Well, yes, I was
Yes.
looking at the type version on page
Yes.
13, but it's the same.
Yes, my lord. That's the evidence of PC Giles that the judge attaches weight to, as we know, and I'm going to come, if I may, to that. Where I'm starting is with the evidence that we know, and it's common ground, that Nicholas gave in November 2015. It was never put to him, you didn't say that in 2015, and there's a misdescription by Hugh Barrow and the like. And how that was converted into a negative for Nicholas's reliability on the basis it's different to what he's said to have said to PC Giles in the note that I've just taken my lord to in response to my lord's question. So that that's, if we go to the judgment at page 86, at paragraph 108, this is where the learned judge addresses this issue and says, "I'm of course aware not only Nicholas's mother disputed the accuracy of part of PC Giles's note, but that Nicholas subsequently provided a significantly different account of what he recalled." And so that's how it became a different account. And then it got worse for the claimant, because the judge then went further in his para 109 that I've taken the court to, and then describes how Nicholas's recollection has suffered from Guessman degrading the quality of recall, without at any point recognising that he gave a clear description from November 15 at the latest that he never resiled from, and that is the only evidence that's consistent, straight up consistent, with the hard evidence that subsequently emerged. And nowhere do you see the judge recognise the force of that submission. And the reason he doesn't is because, exactly as observed from a Lady Justice Laing, he has not considered that evidence to be really important. And that's why it's of a piece with his identification of the core issues as being different issues, and with his stating in clear terms repeatedly through his judgment, this is to be determined by way of dispute between factual witnesses only. So, yes, he relied upon the evidence of PC Giles in circumstances where there are multiple difficulties with his having done so in the face of recognition of the quality of Nicholas's evidence so soon after the accident and in advance of the hard evidence emerging. This obviously involved, this goes back to the point that my Lady Justice Macur has made, that we have to look at it in the whole, because he only gets to make these conclusory assessments when the balls are in the air and when he's performing his balancing exercise. So that if in performing the balancing exercise he has not attached significant or sufficient weight to the evidence that Nicholas has repeatedly given from November 2015, if not before and ongoing, the whole process falls foul. And that's why one doesn't and can't then put it in the silo and say, well, okay, but he did fine for PC Giles. Because when one looks at how he managed to fine for PC Giles, one sees the following. First of all, his evidence at trial was based upon his having refreshed his memory by having recourse to his notebook. I'll just give you the reference for that. I don't need to take you to it, but it's supplemental bundle page 179, and it's also referred in our skeleton argument. And that's why we say in our written submission that his evidence reduces to saying, I've written it down so it must be right. That was PC Giles' evidence. And very concerning is how the judge is clearly himself impressed by PC Giles, in the judge's words, having none of it. See the judgment at paragraph 60. This is page 75. This is challenges to the reliability of his accounts. Para 60. PC Giles was having none of it. Now this is precisely the judge falling into the Guestman trap of being impressed by the certainty with which the paradigm professional witness, a police officer who deals with road traffic cases, as he explained in his cross-examination, day in, day out, gives his evidence. And this court, from its experience in criminal cases when sitting at first instance amongst other experiences, will no doubt recall how certain a police officer can be in those situations, based upon a note that he can't remember, but he recorded it, so it must be right. Next, the circumstances in which Nicholas gave this evidence should surely be a cause for concern. We've set these out. If the court kindly goes back to page 25 of the core bundle, at paragraph 34, this is all common ground, and we've given the references, so I won't need to rehearse the references. Court see that, paragraph 34. So this conversation lasted only a couple of minutes in the doorway of the Barrow home, 1 hour after collision, when Nicholas was, unsurprisingly, traumatised, he's 11 years old, and very upset. When PC Giles already had it in his head because he'd spoken to Mrs. Merrett that the claimant had run out, and when PC Giles did not read his record back to Nicholas, didn't read his record back to Nicholas's mother, who was with Nicholas, let alone ask either of them to sign his record. And finally, even when looking at the record, which was the SB3 that I've taken the court to just earlier, the key description, then ran across road, slipped and hit car. Running across the road is not the evidence that Nicholas gave from November 2015 onwards. That is different. Although again, and this is why I've given these may seem ambivalent or difficult or defensive answers, but they're not intended to be, is because is the key question, did he run out into the road? Not exactly. Because even if he ran out before he slipped and fell on his bottom, was getting up, as I say, that only goes to contributory negligence. Isn't actually the core issue there. The core issue, as I keep coming back to, is whether he was going down or intending to go up, whether he was stationary or actually moving up. Doesn't matter. So actually, even the description, so this is now against the claimant saying, well, there we are, that's a description. Even the description run isn't determinative. And if you look at the description, slipped and hit car, Nicholas does describe the claimant slipping. And slipping naturally describes someone falling backwards, not going forwards. If you slip backwards like that. Fall forwards, slip backwards. And did he slip per Nicholas? Yes. Did he hit the car? Yes. So what you have is a compressed and incomplete description that Nicholas has given. Why is it not more complete? Because PC Giles spoke for a very short period of time to a traumatised and upset 11-year-old boy an hour after the accident. So should it come as any surprise to the court that we don't have, in a document not signed, not approved by Nicholas or his mother, we don't have a fuller account, even if one says this is evidence that one should take at face value, in the face of all of the concerns that we have about that evidence. So that's why we say we have a real problem when the learned judge has not attached weight at all. It's gone completely in reverse to the fact that Nicholas gave clear evidence from November 15 onwards That is a negative. That is a guesstimate negative in circumstances where it can hardly be an issue of poverty of quality of recall within 2 months of the accident.
Why do you say that? People reconstruct what they saw in split-second accidents within hours, if not days.
My Lord, we want to take that sort of approach of concern of anything other than literally what was said in the moment. We wouldn't be having litigation statements at all. We would just be put to you, well, here's a litigation statement. When's it signed? It's signed 4 years after the accident. Goodbye. It's guesstimate. The quality of recall is gone. It's one thing to say over the passage of time. That I can understand. Passage of time. Trial, classic case of trial in 2020. You're being asked to recall what happened in 2015. That one can understand, but not when a description is given, which the witness has maintained throughout from within 2 months of the accident. And as I say, there's no evidence, because it's not Nicholas's evidence that he came to that description in November 15. It's his evidence that's always his description. His mother's evidence that was always his description, all rejected by the court, and put under a cloak of guessman in circumstances when he's not only said this has always been his evidence, but there is hard evidence that it was his evidence in November 2015.
Mr. Witt, I noted down a minute ago, and I just wanted to check this was accurate. You said the key issue was whether Felix was going down or getting up. Is that the key issue?
Yes, my lady, I've sought to make that,
Yes. All right.
clear right at the outset when I'm describing what I say as the key issue.
All right.
But as I say, the process of going down is definitely in motion because you can't be going down and stopping in that position.
Because earlier on in your submissions, I thought you were suggesting that the key point was his body position as per the evidence of Dr Hulse.
Now, my lady, we've got the core issue and we've got the hard evidence. The core issue is was he in the process of going up, claimant's case, or going down, defendant's case?
Right.
The hard evidence is at the point of collision he was in what I'm calling a compressed, crouched, low down position. Is that clear, my lady?
Yeah, it is. And you say that hard evidence would enable the court to determine the core issue.
My lady, exactly, because you test the witness evidence against that, and that is witness evidence. Now I'm on Nicholas, I'm going to come to Mr. Gens and then the respondent. That is core evidence, that is evidence in which Nicholas has given the only description entirely consistent with that from at least November 15. In fact, we know his own evidence is he gave it before then, he gave it to his mother, who's testified to that effect, and his evidence is that's always what he saw. And this has all just been swept to one side. It's never been addressed because the court never started from this right process. So I hope by this point that my lady and Lady Justice Macur will see tracking through, because that's what I'm intending to do when I made that earlier submission of a failure to track through the core issue by reference to the hard evidence.
I understand the submission you're making.
I'm very grateful. To compound matters, and I'm afraid this is where it is. It's not death by a thousand cuts. It's not, but it's an additional factor the court prays in aid, which is remarkably unfair. In our respectful submission, at paragraph 111 of the judgment, page 86. I didn't get to this as the additional part when I was going through the judge's reasoning. But the last part of his reasoning, you'll see he says, I also don't consider it likely that if Felix was in the road for more than a few seconds, Nicholas would have failed to warn him. So this 11-year-old boy not only is told exactly what he subsequently given evidence in relation to from as early as November 15, but now it's a reason not to consider his evidence to be reliable, that this 11-year-old boy should shoulder the responsibility for having called out a warning to his friend as these events unfolded.
I don't understand that, I'm afraid. Why would he be shouldering the responsibility of having called out?
Because the learned judge says he didn't call out, so it didn't happen. Had it happened in the way he described, he would surely have called out. That is deemed to be a factor in favour of rejecting the evidence of Nicholas.
Well, just help me with this, please, Mr. Weir. The judge referred to Nicholas's evidence, oral evidence, in which he does or did accept that he did shout out, "Wait," which the judge then referred back to the first reference to PC Giles's
Yes, my lady.
contemporaneous note.
Sorry.
So we're talking about a different thing.
That's a reference, as I understand it, to before he came out. Before he left the pavement. This is a description the judge is saying, if the claimant had come out, we know it would have taken some seconds, it would talk about 10 seconds and the like, for the claimant to walk across the road, slip, go onto his bottom, get himself into crouch position to get up again when he's hit. And if that had happened, and we've got, it's like the plausibility theory, if that had happened, not only would he have been seen by the drivers, but Nicholas would have called out again.
Right, so can we just look at Nicholas's evidence about the weight and just so I can get this?
And whilst you're doing that, can I just say there is no pavement on the side of the road where Felix
No,
came
sorry.
from. My learned friend has continually referred to the
It's a
pavement.
driveway.
Yes, we understand that, it's a
Yeah.
drive, yes.
Yeah.
So can we just see that part of the evidence, Mr. Weir?
Yes.
Thank you.
I was looking at the PC Giles material on the day. Felix went back home, then came back to the end of his driveway. Stannard shouted words similar to "Wait, there's a car." Barrow then ran across the road, slipped and a collision occurred. None of that tells us whether Nicholas was saying, "Wait, there's a car," before the grey vehicle or after. Maybe it was before.
Page 156.
Yes, yes, it is. It's 156, page 58. If you kindly go to the left-hand column, bottom row, page 58, and then you'll see around lines 5 and following. When you stopped at the side of the road, what cars were on the road, first of all, coming from your left? There was, I think, 2, maybe 3. Well, there was one further in front, which I told him to wait for in case he hadn't seen it. That was the wait before he left the driveway.
Right, okay, so I think I just put my hand up and sort of pointed, but then said wait. Whether he heard the wait, I'm not.
Yeah.
He was obviously going to say sure.
Sure,
or,
not sure.
Yeah. Yeah, thank you.
Can I then turn to the evidence of Mr. Gent? And I should say that I've just worked out that the clock that says 11:35 is inaccurate because
It's an hour slow.
I've been looking at it,
Yeah.
thinking I've done remarkably well on my timing, and then I looked at my watch, discovered I hadn't. My lady, Mr. Gent's evidence, I don't know if it's Gent or Gent, I know my learned friend asked him, but Gent, but it doesn't come through on a transcript. So Mr. Gent's evidence, as we've seen from the judgment at paragraph 104, assumes central importance. And the judge attached particular weight to evidence given immediately after the event. And this we can see from page 85, paragraph 104, right at the end. Does the court see that? A case like
Yes.
many before it, in which the evidence given immediately after the accident tends to be a more reliable source than those created subsequently. And that echoes what he says at paragraph 38 at page 72. Second part of paragraph 38, I won't read it out, but second part of paragraph 38. And this gives rise to a particular source of unfairness when considering Mr. Gent's evidence, because his earliest recorded description is at supplemental bundle page 13. And can the court kindly turn to that? So this is the page that then my Lord Justice Bean was drawing my attention to. And down at the bottom, below the second hole punch, there's of course the Alex Gent.
I'm so sorry, Mr. Weir, I missed it.
It's all right, my lady. It's page 13 of the supplemental bundle, please.
Thank you.
And it's below the second hole punch, i.e. right towards the bottom. And it's preceded by the words Alex Gent.
Yep, got it. Thank you.
And it says, he was travelling generally towards Wickham. He saw the boy run across the road to his mate on the other side of the road. He then saw him bounce off Bonnet and back into Lane he'd run from. He stated he was around 3 lorry lengths away from the scene when it occurred. And just before I make my submission, I'm just going to take you to his litigation statement, which was actually in March 2016, quite soon after the accident, page 26 of the supplemental bundle, please. And if you go to paragraph 4 at the bottom, page 26, my Lord, 26 of the supplemental bundle. Para 4. The vehicle in front of me passed the house. A child sprinted into the road from the left side. Immediately behind the vehicle, he ran straight into the red car, hitting the driver's front headlight. He folded over onto the bonnet and rolled off. So here we've got the judge saying, I'm going to attach particular weight to the evidence which is given in the aftermath of the accident. And the evidence given in the aftermath of the accident is the description of a witness who says, I saw the boy bounce off the bonnet, which he later describes as folding over the bonnet. That evidence, when tested against the hard evidence, so described, is wrong. Pure and simple. It is wrong. There is no damage to the bonnet. The claimant must have been in a crouch position, very low to the ground, when he was hit. And yet, in the face of that, what we have instead by way of analysis from the judge is paragraph 106, page 85. This paragraph is instructive because one clearly sees how the judge has not considered there to be hard evidence against which he needed to test this evidence. Hence his description. He did not recall Felix slipping, and his description of the mechanism of how his body hit the bonnet might not fit precisely with the damage or injuries identified by the experts. That is benevolent plus plus. That is, instead of the judge saying, I am going to apply the proper approach, see Martin, see Lord Bingham, see his own description of objective evidence as a lodestar to guide assessment of witness evidence, his own description of using it to calibrate the reliability of witness evidence. He's armed with hard evidence that the claimant must have been in a low-down, compressed, crouched position. And here is a witness who says at the time he was only 3 lorry lengths away when he saw the claimant bounce off the bonnet, which he describes 6 months after the accident as, bounce off the bonnet and then 6 months after the accident as folding over onto the bonnet. And instead of identifying those precisely as fatal flaws, he describes them in the opposite terms. They are, though, hardly fatal flaws in the credibility of a witness through a split-second collision. Or quite a split second of evidence. A split second of evidence is now determining it. When that evidence is unreliable because it is wrong, explicable as being in a split second, see the evidence which I've sought to take the court to in relation to vehicles in front, and is to be contrasted with the evidence of Nicholas, who has the perfect position from which to see his friend on whom he is focusing, and gives a description from at least November 2015, which is the only description entirely of a piece with the subsequently adduced hard evidence.
Can I just get the chronology right of Mr. Gent or Gent's contact with the police? On the written log on page 8, we see at 9:15, it appears that PC Giles attempts to get in touch with Alex Gent. At sleep, mobile number, no reply, message left. So what we see on page 13 is a report prepared at 13:13. I may have missed it, but is there any indication of when Alex Gent was spoken to?
Well, I'm exactly with your ladyship, having noted also that reference, and then simply rely on this is recorded exactly as your ladyship says at 1:13 in the afternoon. The accident was, I think, 7:30ish or 8 o'clock in the morning, and as to precisely when in that small window, whether this was a description given, an account given at the time, I do not know. Part of PC Giles' evidence is that it comes in a piecemeal fashion, because we see this in relation to Mrs. Merrett, which I'm going to come to in a moment. He has evidence about Mrs. Merrett, which he adduces in November 15, and we don't know if he actually obtained the evidence in October 15. But what we do know is this is aftermath evidence, in the sense of this is on the day of the accident. And that's a description given by Alex Gent on the day of the accident, and it is wrong in a critical part that can be tested. See Lord Bingham, and the benefit and importance of testing against something you know not to be, or you know to be right. As regards then the evidence of the respondent of Mrs. Merrett, I've already taken you to the judgment of paragraph 108, in which, although the judge earlier says Mr. Gent's evidence is key, he nevertheless puts Mrs. Merrett's evidence into the scales, if I can put it that way, against Nicholas at the end of 108. So it is evidence which is, as it seems to me, I'm required to respond to. And all the respondent could say about the appellant's evidence, and this is in circumstances where the judge has found Nicholas's evidence is inconsistent with her evidence, inconsistent with para 108. All she can actually say is recorded in the judgment of paragraph 64, if you kindly go to page 76. 62 and 64. If you start at 62, 3 lines up from the bottom of 62, she stated she assumed he was running because he was in a crouched position. Now at that stage, that was her description, and that is of a piece with the hard evidence, and with the claimant indeed being in a crouched position. See Nicholas's evidence on the way to getting up. Then she was cross-examined, and if you drop down to para 64, I'm not trying to miss out any part, you're welcome to read all of 63, but 64, Mrs. Merrett was very clear in her recollection that she was concentrating on the road ahead, and she only saw Felix a split second before the collision. She stated that when she saw him, he was leaning forward as if he was running. In other words, she did not see him running at all. She saw a split second of the claimant, which she initially described as being in a crouched position, and which she modified when being cross-examined to being in a leaning forwards position as if running. Now, if the claimant was in a crouch position such as described by Nicholas, that is entirely of a piece with the claimant's case, and her evidence is supportive of the claimant's case and anything but inconsistent with it, because all she's describing is seeing him in a split second before the accident. And if not, and leaning forwards means literally no more than tipping forwards, as I'm doing now in court, leaning forwards, as one might normally colloquially say, I'm leaning forwards, then this is part of the response which I've given, which again may have seemed difficult and irritating by way of a response, but in answer to the question, are you saying that that Dr Hulse's evidence is encapsulated in the parts which he gave in cross-examination at paragraph 75 of the judgment? And I'm saying, well, not quite, because in paragraph 75 we've got this, he must have been low enough not to go over the bonnet and high enough not to go underneath the car, and then he effectively sort of, I can't say which in between, or that's the judges, what the judges at 75, just before the quote, whilst Dr Hulse was clear the injuries were inconsistent with him either standing up straight or lying on the ground, beyond this he could not really go. That is not fair or accurate, because leaning forwards in no way is consistent with being in a crouched position, compressed and crouched position, such that your head, your elbow, your femur, your tibia are all very low to the ground and your foot is run over. So no, it's not accepted. In other words, if Mrs. Merrett wants to say he's in a crouched position, her evidence is consistent with the claimant's case. If she wants to describe him as leaning forwards like this, that cannot be so, because he was not merely leaning forwards at all. He was in a completely different position, which I would have to effectively be hidden from the bench. If it were I to adopt it now, I would not be visible to this bench if I was now in the crouched, compressed position.
I bet you would be.
However much your ladyship might welcome, I'm not going to demonstrate it now.
You're a bit bigger than 47 centimetres.
I am, lady, but the position is the same. The adoption of the position is one we can all take. Our overall height differs, but we have the photograph of a boy who's 3 centimetres shorter in the bundle.
Yeah, and we're dealing with Felix, not you.
Oh, absolutely not.
Yeah.
I don't mean to become a sort of witness to my own case.
I'm just explaining, Mr. Weir, why I made the comment, just to get a bit of levity, I suppose, into the submission that you were making, you seeming to offer that you were going to crouch down.
Well, lady, I'm not, I'm afraid.
All right. That's not even just an hour behind. It's now getting.
You've been fooling me all morning, my lady. I have to be said, but there we are. Sorry.
So.
I'm extremely close to the end, my lady.
Yes. All right. I don't want to rush you at all.
So that, my lady, that's again regrettably another part of the evidence in which the learned judge has simply taken evidence and said, I'm going to place it on this side of the balance, when it cannot belong on that side of the balance at all. And of course, once you start with a plausibility theory that says, well, I'm sure the driver's not going to miss something, you can see how these sorts of difficulties arise, which is why they're all linked, the submissions we make in relation to identification of core issues, plausibility theories, adopting Guestman in the way that's been done, etc. But those are fundamental problems, because that's all Mrs. Merrett could say. And when then going back to the well, just for a moment, staying with that again, we see the slanted way in which the judges approach matters, because Nicholas is described, judgment paragraph 43, page 73, as recorded as giving at least 5 accounts of what occurred. Full stop, but left on its own has a whiff of pejorative about it. Mrs. Merrett gave at least 5 accounts of what happened. but we don't see that in the judgment. Mrs. Merrett gave the account to PC Giles at the time of the accident. We see this at page 28 of the supplemental bundle. Paragraph 4. And that ties in with page 13, first hole punch of the supplemental bundle, which says the initial count of Merrett, etc. Which says it was a vehicle passed her going in the opposite direction, and as soon as it passed, Barrow appeared and collided with her vehicle. Because in substance, that's it. That's her evidence. He appeared in this split second before, and a collision occurred. She gave evidence to PC Wheeler, and we see this in the supplemental bundle at pages 61 to 62. And if you pick it up between the hole punches at 61, noted a young lad on pathway on near side, that's Nicholas. Then from nowhere, boy appeared behind dark car running to other side of road from offside. States she felt the boy hit the front offside and drove over him, felt him under the wheels. States was travelling at speed limit, etc. Then she gave evidence somewhere along the line to PC Giles, because we see this at page 18. This is evidence again which can easily explain away the so-called plausibility theory. This is second half of page 18, second hole punch, pretty much opposite. This is an email from PC Giles. As I say, we don't know when he spoke to Mrs. Merrett to obtain this evidence, but Rosemary Merrett said, as she came along the road, knowing it's a 30-mile-an-hour speed limit, she could see the boy on her side of the road, Nick, and thought he might come out, as she used to work at Swanmore School. Car passed and Felix appeared and was running before the collision occurred. And she was taken to that evidence in cross-examination, accepted that if PC Giles says that's what happened, that's what she told him, then that's what she told him. And then she gave a litigation statement, and then she gave evidence at trial, and those are 5 accounts. I'm not saying that's a sin. I'm just saying that I'm afraid it's part of how the evidence has come out, or how the judge has approached the evidence that's come out, to describe it in the way he's done in relation to one witness, but not another in that way. I was going then to address the plausibility theory, but I think by now I've almost certainly completely made my submissions in relation to the plausibility theory anymore, probably.
Well, you've tracked it all the way through.
Well, I hope so, lady, but probably at least one step too far. Well, lady, it's for those reasons that we say there really is a hard-edged appeal here, as opposed to the very hard to maintain challenge to primary facts, dipping in and out of the evidence, etc. We've not sought to dip in and out of the evidence, we've sought to address all of the evidence that the judge addressed, almost entirely by reference to the judgment. I took you through Dr Hulse just because there seemed to be an issue. My learned friend will develop it in the way he sees fit, so it's quite helpful for me to have, I hope, taken you through and shown you what Dr Hulse has said and what he hasn't said, long before he was cross-examined, but as the lady rightly observed, ultimately makes no difference because it's his evidence that counts, not how we got there. So that's his evidence. But this is a hard-edged appeal because it is by reference to the hard evidence, so-called, that the judge should have tested the key witnesses. And had he done so, he would and should have placed great weight on the consistency of Nicholas's evidence on Nicholas's evidence throughout, and as proven to be the case from, by chance, if you like, or happenstance, November 2015, within 2 months of the accident, and long before there was evidence that he must be in this crouched and compressed position. You've got Mr. Gent, who does not describe him in that position at all when saying he's got an unobstructed view 3 lorry lengths away. And the judge says, I attach great weight to what's said initially after the accident, and that's what he said initially after the accident. You apply the process of assessing the evidence by reference to something you know to be right. It's the most effective way. And Mrs. Merrett, to the extent that the court also placed her as an additional weight in the balance against the evidence of Nicholas, is able to say only in essence, in a split second, I saw a boy who was either A, crouched, or B, I've changed my evidence, I'd now say crouch means leaning forwards. One is right and fits with the claimant's evidence, the second is wrong. Leaning forwards is no more than tipping at the hips. Tipping at the hips will not suffice to put the claimant in that body position at all. And it's for those composite reasons that we respectfully submit that the first step this court is mandated to take is to set aside the judgment. The second step it can choose to take or not is to find for the claimant. Otherwise, this is a case in which the value of the claim makes it a proportionate measure to order a retrial.
Any questions, David? Any questions? Thank you very much, Mr. Weir. Mr. Sullivan, would you like to start after the short adjournment?
My lady, yes, I keep looking at that clock. I don't know why. Forgive me.
Yes.
I have checked my phone. I would be happy to do so after the short adjournment.
Yes, I think so.
Are we saying, my lady, 2 o'clock or 2:05?
I think we're going to say 2:05.
Very much obliged, my lady.
Yes, thank you. I should say, I didn't mean to be rude, Mr. Burton. You don't follow.
I don't. I'm great.
Should I say an open question? Do you follow?
No, I do.
No.
Very good.
Thank you very much.
Court rise.
Right.